Good morning or afternoon. Once again, welcome back to the 8th Harvard International Arbitration Conference. I now have the honor to introduce the second panel of the day. The panelists will be talking to you about the arbitrator's power to review contracts, hardship, and force majeure in comparative perspectives. Our first panelist is Nicole Duclos. Nicole is a Chilean, New York-based partner at Covington. She represents clients in international commercial and international investment arbitrations, as well as transnational litigation. Her experience spans over construction, energy, mining, agro-industry, and finance, among other industries with a focus on Latin America. And she is a dual qualified lawyer in New York and Chile. Our second panelist is Dr. Johannes Willem. He is a Frankfurt, Paris, and London-based partner at Jones Day. He has handled large-scale and high-stakes international arbitrations and complex litigations. His vast experience includes antitrust, corporate and post-transaction, energy, engineering, construction, distribution, insurance, IP, and regulatory disputes. And he also sits as arbitrator. He is qualified in both Germany and Austria. And our last panelist for the day is Sven Volkmer, who is a New York-based partner at White & Case. His practice covers both investment and commercial arbitrations with a focus on energy-related disputes. He is also a member of both the New York and Paris bars. I wish everyone a wonderful panel and now leave the floor to our three speakers.
And all of you, Elisa, for inviting us to speak today. It really is a pleasure to be here. I'll start the panel today with a question. What do climate change, the COVID pandemic, and the war in Ukraine all have in common? Well, aside from being pressing issues of our time, they have all given rise, directly or indirectly, to claims of hardship and force majeure. And these examples give us a sense of what hardship and force majeure are about, namely unforeseeable, unavoidable, and often extreme changes in circumstances that have the potential to fundamentally disrupt contractual relationships. At their core, force majeure and hardship try to address a tension between two competing objectives. That is predictability and flexibility. This tension exists in virtually all long-term contracts. On the one hand, parties want to know what they're required to do and they can expect from their counterparts. On the other hand, parties acknowledge that no one can predict the future. If you're a friend of Latin maxims, you can describe this tension in terms of pacta sunt servanda and rebus sic stantibus. On the one hand, agreements must be kept. On the other hand, this assumes that the circumstances existing at the time the contract was concluded remain the same. And if they don't, then it might be appropriate to amend or terminate an agreement. Our panel will explore force majeure and hardship, as well as other contractual mechanisms for dealing with changes in circumstances, such as price revision clauses. And the focus will be on the available remedies, in particular, the power of arbitrators to modify contracts. So here's a broad overview of what we plan to cover. Johannes will start us off with a bit of the commercial context in which force majeure and hardship tends to arise. And Nicole will give us an overview of some of the key concepts in that area. We'll then briefly discuss the conditions for invoking force majeure and hardship, as well as related doctrines. And then we'll focus on remedies, notably the power to modify contracts. One of the questions in that context will be how extensive is the power to modify contracts of arbitrators, and what limits may the parties want to impose on that power. And finally, if we have enough time, we'll discuss a little bit some practical considerations for force majeure and hardship and share some war stories. That's a lot of ground to cover. So without further ado, I give the floor to Johannes.
It's really a great pleasure to be with all of you. I'm honored to be with this esteemed panel. Let me just set the stage very quickly for today's panel. In essence, every legal agreement, or in better terms, every commercial transaction is in essence an allocation of risks. Typical risks are price risks, volume risks, risk of quality, any type of performance risk, such as the risk of impossibility or altered performance options, and how these risks are allocated between the parties is either determined by a specific agreement or it is determined by the law governing the agreement. Now, in essence, every dispute and every adjudication in arbitration is a determination of how these risks were allocated, if at all, and what the law foresees as a consequence of one of the risks materializing. Now, this panel will look at something very specific and something as timely as it couldn't be, namely the situation in which the risks change so fundamentally, or the circumstances which determine legal and commercial risks change so fundamentally that it's no longer reflected in either the agreement or the law. Now, these type of contracts really form a great majority of arbitration cases in different phases, and they affect a multitude of agreements. As Sven already mentioned, the typical scenario are long-term agreements. But what kind of long-term agreements? It's long-term supply agreements, be it energy supply or any other commodity. It's lease agreements, rent agreements. It's joint ventures such as joint research and development projects. It's license agreements, but it's also single individual transactions such as purchase agreements or, which doesn't come up so many times in arbitration, travel agreements. And what are the typical scenarios in which changes of the risk allocation are so fundamental that they need sort of the arbitrators need to revisit the entire equilibrium and have to find the appropriate remedies? It is typically changes in markets. Changes in markets can be triggered by acts of God, and we'll talk a lot about that, such as war, weather, but also fundamental regulatory changes. We will see this in the days to come with the Ukrainian crisis, where, for example, the European Union changed the regulatory regime of how energy is being supplied to Europe so fundamentally that it will affect all commercial transactions. And with that, I think we're ready to start into looking more into detail of the different concepts such as force majeure, hardship, frustration of purpose, and then price revisions. And with that, I hand over to Nicole.
Thank you so much, Johannes. Again, it's a pleasure to be here. Thank you to Harvard Law School for inviting us. It's been a pleasure to work with my panelists as well. I want to pick up on a few things that Johannes said, but maybe start with a very basic proposition, but relevant nonetheless to our discussion. As a general matter, contractual non-performance doesn't require fault by the non-performing party. And similarly, the force majeure excuse to non-performance is not defined as the absence of fault, but rather force majeure excuses liability for non-performance where an unforeseeable and irresistible event renders that performance impossible. And that may lead to a suspension of performance or potentially even contract termination. Now, the impediment that hinders performance must be, however, beyond the control of the non-performing party. And Johannes gave a couple of examples, and we're leaving times where those are easily available to mention. But that party must not, and this is something Johannes mentioned too, risk. That party must not have assumed the risk of that event occurring. Now, by contrast, where the non-performing party has guaranteed certain performance or has otherwise assumed the risk of that event's occurrence, then that party will be liable, even if it isn't at fault, and even if it has used its best efforts to achieve what has promised. So that sort of is an initial sort of reflection on these issues. Now, we were given the mandate to point to distinctions between the civil law and common law, and we'll try to do that when applicable. And one very important distinction, at least as force majeure is concerned, between civil law and common law is that under common law, force majeure is a contractual doctrine, which means that in order to be invoked as a defense for non-performance, force majeure must have been included in the relevant contract. Now, that said, most contracts, and we're talking about international arbitration, most cross-border contracts would include a force majeure clause, and those clauses would list the events that, and it can be an exhaustive list, a non-exhaustive list, such as natural disasters or epidemics or war or terrorism or acts of government. And in fact, the parties are free to stipulate that any event shall be regarded as force majeure, irrespective of the conditions that must be met under applicable law. And that is important. I've been faced with force majeure clauses where the list doesn't necessarily include the events that we've mentioned here. So if we go to examples in common law in New York, where I practice, force majeure is narrowly applied and interpreted, and the event must be unexpected and beyond the party's reasonable control. And importantly, it only provides relief to the non-performing party if the event at issue is specifically included in the clause. Now, if we've seen force majeure clauses that have a catch-all sentence, and in those cases, the event would only fall within the force majeure doctrine if it is of the same kind of nature of those actually listed. Now, not all states have the same approach. If one goes to California, for example, there's some authority for the proposition that even an event that is not specified in the clause may exempt liability, provided that is unforeseeable. So not all jurisdictions are the same. Now, if you move to this civil law context, force majeure may be found in codes, civil codes, statutes, laws, and therefore may be invoked even if the contract at issue doesn't have a force majeure clause. And that is, I think, a very important distinction. Now, regardless of whether you're in the civil law or common law spectrum, burden of proof issues are relevant. The party invoking force majeure must prove it. And in fact, the presumption that an event that is listed in a force majeure clause is unforeseeable and irresistible may be overcome based on evidence to the contrary. And even, for example, armed conflict, one may ask if a contract is concluded at a time when armed conflict is foreseeable, would it qualify as a force majeure event? And then the party invoking the force majeure clause must show causation and demonstrate that performance is indeed impossible. Now, very briefly, and before passing it over to Sven, I want to mention two other doctrines that are similar, but there are important differences under common law. Impossibility or impracticability is another, provides relief also at common law, apart from force majeure, and excuses a party's performance only when the destruction of the subject matter of the contract or the means for performance of the contract by an act or God or a superior force or law makes that performance impossible. An example, a case where it was upheld, a court excused a fabric supplier from performing under the supply contract where the government had requisitioned all clothing material to meet wartime needs, for example. Importantly, for example, under New York law, the performance must be objectively impossible. And it's not, again, economic hardship, for example, even to the point of bankruptcy, wouldn't render performance of a contract impossible. And lastly, frustration of purpose also is another common law doctrine that may excuse performance. And it applies when, due to a supervening event, a party's principal known purpose for having entered a contract is destroyed, obviated, or no longer exists, even if performance is possible. So unlike the other two doctrines, performance may be possible, but the purpose behind the contract is no longer there, and the event obviously must not be reasonably foreseeable. There is an example of an operator of movie theaters, dining movie theaters, and the operator was looking to either delay the payment of the lease or just not pay it altogether because the government had ordered the shutdown of all movie theaters, and the court did find that due to the shutdown, the purpose of the lease had disappeared. Now, then the shutdown was lifted, and the operator wanted to still not pay the lease, and it argued that due to the pandemic, there weren't enough movie releases, and that was the whole purpose of having the theaters. The court did not agree with that one because the purpose was still there. Maybe not that many people were showing up at the movie theater, but nonetheless, the purpose still was hadn't been destroyed. So these are some of the key concepts. And Sven, I don't know if you want to continue explaining a few others.
Perhaps briefly on hardship, which is a related but distinct concept in this area. The bar for hardship tends to be lower than for force majeure. So it's not necessarily about the impossibility of performing a contract, but about a disruption of the fundamental equilibrium of the contract. That doctrine is codified, for example, in France, and the French Civil Code provides that if a change in circumstances was unforeseeable at the time of the conclusion of the contract and renders performance, quote unquote, excessively onerous for a party, then performance may be excused or there may be a renegotiation of obligations. So the operative phrase here is excessively onerous as opposed to impossible. The Unidroit principles put this in a slightly different form. They say that hardship applies where there's an occurrence of an event that fundamentally alters the equilibrium of the contract. So again, something that has a fundamental impact, but is not quite as dramatic or drastic as making a performance impossible. Now, what about common law jurisdictions? Just like there is no force majeure doctrine in common law, there is also no hardship doctrine. That's a pretty significant difference between the two civil law and common law jurisdictions. In simplified terms, you might say that common law places a higher value on predictability than on flexibility. But the parties can, of course, include a hardship clause in their contract, and they often do so, in particular in long-term contracts, where you can expect that some change will occur, even if you don't know exactly what that change will be. To borrow a phrase from Donald Rumsfeld, it's about known unknowns, right? You know that something is going to happen, even if you don't know exactly what that is going to be. Sophisticated commercial parties often do include hardship clauses in their contracts. So the difference between common law and civil law in this area is arguably not that important in practice, and appears perhaps more important in theory, at least in the kinds of cases in international arbitration that we tend to come across. Johannes, do you have anything to add on that from a civil law perspective?
I don't really have to add a lot. This is all being covered. The only focus I would want to look at very briefly is, I think, where individual jurisdictions in civil law countries vary is on the assessment of various situations as either qualifying force majeure or hardship, so the individual approach, and more so in the available remedies. There are some jurisdictions where changes of circumstances can only lead to a termination of a contract. Whereas in other jurisdictions, and I think this will be a core of our discussion on the powers of tribunals, is that changed circumstances may actually entitle to a modification of the agreement and the main terms of the agreement, such as the pricing terms, the volume terms. So the big difference is in what remedies are actually available. Germany allows expressly termination or contract modification. That's the only thing I wanted to add to this aspect, and we'll revisit it when we speak about price revision clauses and contract drafting and remedies.
On to some of the considerations for invoking force majeure and hardship. And rather than walking through all of those conditions sort of one by one, I propose to address 2 points. One is that financial hardship is typically not enough to invoke force majeure or similar doctrines, but events that qualify as force majeure may of course lead to financial hardship. And the second point is that I'll briefly talk about contracting out of national regimes on force majeure. So on the first point, Nicole touched on this already. Typically, financial hardship is not enough to invoke force majeure. That point, for example, was made in one of the seminal cases in England on this topic, where it was said that hardship or convenience or material loss itself, which is not what calls the principle of frustration into play, but rather there must be a significant change in the obligation itself. So that's a pretty high bar. Frustration requires not just an external change in circumstances, but a change of the contractual obligation itself in those changed circumstances. Under New York law, the courts have gone so far as to clarify that even if a party goes bankrupt or insolvent, that in and of itself does not excuse performance. So again, changes in economic circumstances, probably not enough to invoke frustration or force majeure. But of course, the inverse may be true. There may be changes that are so dramatic that they qualify as force majeure or frustration, and at the same time impose extreme hardship on one of the parties. To give you one example of that, case that I've been involved in concerned the construction and operation of a terminal for the importation and regasification of liquefied natural gas in the US. That terminal was going to be operated for decades at a cost of hundreds of millions of dollars per year. The contract was concluded at a time when the US was a gas importer. Now that changed with the so-called shale gas revolution, when significant deposits of natural gas became available in the US, and the US changed from being an importer to being actually a gas exporter. So in that new context, having a gas import terminal really didn't make any sense anymore, and that terminal was not going to be used in practice. So one of the parties brought a claim and said, this purpose of this contract has been frustrated under New York law. And the tribunal agreed and said, yeah, in this new environment, it makes no sense for hundreds of millions of dollars to change hands, and we're going to discharge both parties from their obligations. So then,
Sven, may I add something?
Go ahead.
I just wanted to, so first of all, I want to endorse everything you say, but I think there are two timely examples where sort of the principle that economic risks are not enough may actually come under scrutiny right now. And I think two examples are, first, the supply chain issues we face worldwide, such as the capacity on container ships from Asia to Europe. and the doubling of prices for container cargoes. Now, it may well be that this is an economic risk, which is so beyond what suppliers have ever seen that they may actually be in a position to invoke even an economic risk, a financial risk, as a changed circumstance, which may allow an amendment for a contract or maybe a termination. The other thing is there's many relevant supply contract with Russian counterparties where the Russian counterparties may, by operation of law, by order of law, no longer be in a position to accept any other currencies than the Russian state currency, the ruble. And that may make it impossible for them to continue performance of their contracts if the counterparty cannot accommodate for the necessity to change the currency. So what I'm saying is we are in a situation where all the types of disputes we are just discussing right now may soon become the subject matter of very critical decisions.
I think that's a good comment. Everything that I mentioned at the beginning is very likely to give rise to hundreds, thousands, who knows, of disputes in this particular area. So we're living in an interesting time for the law. Now then, briefly on the second point that I mentioned earlier, which is contracting out of national regimes on force majeure. I'll illustrate this by reference to a case from France from the Paris Commercial Court. That was a case between EDF, which is a very large power producer in France, and Total Direct Energie, a French electricity utility. The two had concluded a framework agreement whereby Total could purchase electricity from EDF and then resell that electricity to its customers in France. Now, the French Civil Code has a force majeure provision, but the parties decided to have their own force majeure clause in their contract. And that clause said along the lines of force majeure means an external, irresistible, and unpredictable event, making it impossible to perform the parties' obligations under reasonable economic conditions. So at first sight, that might sound like a pretty standard force majeure clause, but there is a twist, and we'll come to that. So why did the two end up in court? Well, as a result of the COVID pandemic, demand for electricity dropped significantly, and Total had bought electricity in advance from EDF for the year 2020. Now it couldn't sell all of the electricity anymore to its customers and had to sell some of it at pretty low prices at a loss on the wholesale market. Now, the Paris Commercial Court found that the COVID pandemic did not make it impossible to comply with the contractual obligations. Total could continue buying electricity, offtake that electricity, and just sell it at a loss on the wholesale market. But the clause, the force majeure clause in this case, it didn't just refer to impossibility. It referred to impossibility under reasonable economic conditions. And according to the court, it was not economically reasonable to require Total to continue purchasing electricity only to sell it then at a loss on the wholesale market. So as a result, the court said, we suspend the obligation to offtake electricity and pay for it. And what does that show? It shows at a very basic level, you can contract out of national regimes on, for example, force majeure. It also shows that you really have to be careful in your drafting and look at what the clause really says. In this case, arguably what looked like a force majeure provision in the end had more of the effect of a hardship provision, right? It was more about the economic reasonableness of the contractual obligation continuing rather than impossibility, which you would normally associate with force majeure. Okay, and then I'll give the floor back to Johannes. I think you're going to talk about a very specific type of hardship clause, price review clauses.
Yeah, thank you. Maybe not so much hardship clauses, but a beast on its own. So far, we covered, I think, two situations. First, changes of circumstances which were not foreseen in the contract and which either were addressed by a hardship clause or a force majeure clause, which ultimately excuse a party from performance or may allow a party to terminate an agreement. Price revision clauses are something very exceptional if you think about it from a mere contract law point of view. In essence, parties agree at the time of the conclusion of a contract on certain terms, including overall the allocations of risks, as we said at the beginning. Now, unless there is a price revision clause or even a broader contract revision clause, the parties are bound to the terms upon which they agreed, and they may exercise certain rights, such as early termination rights, or invoke a force majeure clause, or invoke a hardship clause, and again, either to be excused from performing the contract or to be allowed to terminate the contract. But a price revision clause is something very specific. It is the acknowledgement of the parties that over the term of a contract, relevant circumstances, such as in particular market circumstances, may change. And they may change in a way that it affects the equilibrium of the contract in such a way that they have to readjust it to the changed circumstances. And so what the parties do, and that's sort of the variations, they either agree to be entitled to request that the contract be renegotiated, so-called negotiation clauses, which then allows them to request to sit down and negotiate. And you find this a lot, for example, in Asian energy supply agreements, but which ultimately does not give a party the right to unilaterally amend the conditions of a contract if the parties fail to agree on new terms to reflect the changed circumstances. Now, a price revision clause goes beyond that. It sort of foresees that the parties meet and negotiate and find new terms to adopt to the changed circumstances, but it also gives a party a unilateral right to have the contract amended without the consent of the other party. How do parties determine how the contract be amended? And that's sort of, again, very interesting for our debate and our discussion, is they can either be very specific on how the contract must be amended in case they cannot agree on amended together by means of agreement, or they can give broad discretion on how to amend the contracts to the decision maker for the purposes of our discussion on arbitral tribunal. So they can say, if we fail to agree on how to adjust the contract shall be adjusted based on the following criteria. And they give very specific criteria, such as what market conditions you have to look at, such as price quotations at certain markets. Or they can just say, the arbitrators shall have the power to replace our agreement and to adjust the contract how it is. Now, when we will look at remedies and when we will look at pitfalls, we will see that a great problem is between the deviation of what the parties want the arbitrators to do, such as amend the contract for us to reflect the terms, to what arbitrators are actually allowed to do under the laws of arbitration at the place of arbitration. Now, to sum up, price revision clauses are giving a party an entitlement to have the contract adjusted, either under specific criteria or very broad discretion of a decision maker if certain conditions are met, to reestablish the contractual equilibrium. And we will talk about how these price revision clauses interrelate with other rights, such as force majeure, changed circumstances, or hardship. And with that, I think we can move on and we will revisit the issue when we come to how they relate to one another and what are the actual remedies and pitfalls. Thank you, Sven.
All right, so let's talk about remedies now in a bit more detail. And let's talk about starting with force majeure and hardship. At a high level, I think we already heard that force majeure is about excusing performance. It can be, for example, a suspension of an obligation if the force majeure event is temporary, or it can be the termination of a contract if the force majeure event is considered to be permanent. Arbitral tribunals are readily able to decide whether a contract should be terminated or not. That falls within their scope of competence. No real difficulty there. It's a sort of an all or nothing kind of outcome, if you will. Now, hardship can be and is often about modifying a contract and not just terminating or suspending it. And that, of course, can be a lot more complicated. We saw earlier that there is no hardship doctrine under common law, so no power to amend contracts under common law unless the parties give that power to a tribunal or to courts. The absence of that power arguably serves the goal of predictability and certainty. Again, the parties know what to expect, and they know there won't be any change, even if circumstances change. But not everyone agrees that that is a commercially sensible solution. Some of the leading commentators in England have said that most commercial parties would find that this is a quote-unquote offensive conclusion if business people are kept to agreements, even if circumstances have completely changed. Interestingly, under French law, the position used to be the same as under English law. There used to be no power to modify contracts. And that gave rise to a well-known case where the fees that were charged for the use of a canal could not be changed even 300 years after those fees had initially been set. French law introduced that power to amend contracts about 100 years ago. That was the théorie de l'imprévision, and that was then extended very recently, only in 2016, to all civil law contracts. So arguably, that's a case of the law catching up with the expectations of commercial parties. Of course, parties can always include an amendment clause, a modification clause in their agreements, and that, of course, is the case under French law as well. I mentioned already that modifying a contract is not always straightforward, particularly if under national laws, there's very little guidance as to how the court or tribunal is to go about changing the contract, even if there's an agreement that there is a basis to do so. The parties in an arbitration can, of course, propose an appropriate modification, but what if the tribunal doesn't agree with either of those modifications and thinks that neither one is the right way to go? What do we do with that? And if a tribunal is satisfied that there is a basis to modify, can it or should it completely rewrite the contract, or should it be very discreet and limited in its adjustments to the contract, knowing the consequences for the parties? Parties can be very apprehensive of giving an extended power to arbitrators to rewrite a contract, especially long-term contracts where you might be stuck with an imposed solution by lawyers, not business people, over years and perhaps decades. Maybe I'll give just one example of that, which is sort of an infamous example from the area of price reviews. This was a case between a Spanish company and a Trinidadian company for the sale and supply of LNG. That contract allowed the buyer in Spain to accept deliveries of these LNG cargoes either in Spain or redirect them to the United States. The price was very much based on gas in Europe, not in the US. And at some point, markets developed in such a way that it was very profitable for the buyer to say, actually, I would like to ship all of these cargoes to the US. I'll get a great price for this, and I'll make a profit on every single cargo. And the seller turned around and said, well, that's not really what this agreement was going to be about. This was going to be about deliveries to Spain. So let's invoke this price review clause and adjust the price to something more appropriate than what is going on right now. The tribunal found that the conditions for reviewing the price had been satisfied, but it didn't like the proposals put forward by either of the parties for how to revise the contract. And the contract gave the tribunal very broad powers to revise the price. It said that the adjustment of the price should be quote unquote fair and equitable. Hardly anything broader than that. So the tribunal came up with its own price and said, I'm going to impose a dual pricing structure with one price for Spain and one price for the US and New England. And depending on where the cargoes go and how many cargoes, one price applies or the other. Now, the seller did not like that outcome at all and applied to the New York courts to have that award set aside. And the argument was that the tribunal exceeded its powers because it imposed a solution that had not been agreed or proposed by either of the parties. Classic ground for seeking set-aside, accession, or exceeding powers of the tribunal. The court in New York rejected that challenge and said, given the very broad powers that the tribunal had to impose a fair and equitable revision, really nothing that we see here went beyond that power, and really you can't complain when you give the tribunal that kind of power. Interestingly, the tribunal actually had asked the parties before the post-hearing briefs, what if we were to impose a dual pricing structure? What do you think of that? And both parties said, no way, this is not what we want. And even that was not enough in the eyes of the court in New York to find that the arbitrators exceeded their powers, again, because of this broad power to impose a fair and equitable revision. So a bit of a cautionary tale. When you give that kind of power to arbitrators, you might have a strong incentive to try to find a negotiated outcome rather than go to arbitration. And with that, I think I'll give it back to Nicole. I think you have also some more practical examples in the area of force majeure and hardship.
Thank you, Sven. Maybe I want to follow up on a couple of points that you both made. First, I mean, obviously, arbitration is a creature of contract, and we're focusing so far exclusively on the power that the parties grant the arbitrators to do this. But I think it's worth mentioning that there are other mechanisms available to parties in addition to crafting these price review clauses or the clauses that you just described, Sven, to accommodate or adapt the contract to new circumstances. And so this was decades ago, but the ICC even came up with, in the 70s, with rules for the adaptation of contracts, whereby that it resembles really expert determination more than anything else, but the parties could agree in their own contract to submit issues of contract adaptation should circumstances change. They could agree on having a third party, either a panel or a sole expert, look at the contract, examine the parties' proposals on how to adapt the contract, and then suggest wording to that effect. And that is not too different from expert determination clauses, which can be used, in a huge range of circumstances, not post-closing price reviews and accounting issues, but also potentially on contract adaptation to new circumstances. So I just wanted to make that point because I think the parties should think, and they do think about these issues, but maybe there are mechanisms that go beyond just arbitration to do so. I had a case that was particularly interesting, civil law governed in Latin America, where the parties, it was a contract between the state agency and a contractor that was to build a plant and then operate it and maintain it. But what was particular about it is that it had both a price review mechanism for the sale of water by the operator, but also a clause that provided for the restoration of the economic balance of the contract and gave either party, but most likely the operator, the ability to invoke this economic imbalance and have it restored by a tribunal. But there was also a price review mechanism. So I take it that when they drafted this, they envisioned a price adjustment should certain parameters get triggered, but also potentially other sources of economic imbalance. So the case was longer than expected. Started with the price review formula that was triggered by certain government acts, and then the economic clause was invoked as well. And ultimately, the price review clause was enough to address the new circumstances that arose. But it is interesting simply because it has this combination of price review mechanism that Johannes described, where the parties are aware the circumstances may change and therefore craft the mechanism and the price formula. But on the other hand, these other civil law mechanisms that we see about economic imbalance that are not unusual. For force majeure, I mean, I think to some extent we've all faced cases, and I have of ongoing contracts where the COVID pandemic and government measures aimed at mitigating the impact of the pandemic have disrupted ongoing contracts. For example, also civil law governed construction contract underway, impacted by COVID and the government measures. Is a civil law jurisdiction, so there is a force majeure definition in the code. But in addition, the contract itself has a force majeure clause that defines it. Now, a pandemic's not listed as an event that could give rise to force majeure, but the code is broad enough, and the jurisprudence, or while non-binding, is out there confirming that it is a force majeure event, and the government conduct is listed on top of that. So there wasn't a bit of an issue as to whether the pandemic is a force majeure event. I think that wasn't contested, but other issues or other elements of a force majeure clause, such as notice and mitigation, did come into play. And it may seem a superficial requirement, but I cannot emphasize enough how important those procedural steps are for purposes of invoking those clauses and seeking exemption. Notice within a certain period of time, notice to certain individuals, and delivered in a certain way. It does matter. And what the non-performing party does when faced with a force majeure event is similarly very important, and mitigation, I think, applies in both systems, civil law and common law. So in this case in particular, the construction schedule was extended for the time during which those measures were in place. And then a different issue, and this goes to what my colleagues have mentioned here, the costs associated with issues such as delay, and the burden of having to ultimately perform during the pandemic, even if the government measures are lifted, are the subject now of separate discussion. I have another example, but I don't know, Sven, if we're going to run out of time, so I may give it back to you.
All right. I think, Johannes, you are also going to address some practical examples, and then if we have time, we can come back to Nicole in a bit.
Thank you, Sven. I try to keep it short. There's a few things I want all of you to take home, and that's first the interrelationship between price revision clauses, force majeure, hardship clauses, and then some powers of the tribunal, competence issues, and drafting issues. So how to tie this together. First of all, price revision clauses, as I said, sort of replace the parties' agreement and change the terms, the commercial terms, or the risk allocation of a contract during its term, even against a will of a party under certain conditions. Now, what we have to be aware of, because we could say or think, well, if the parties agreed upon a price revision clause, then force majeure or hardship may never come into play, in particular non-hardship. But you have to imagine that not everything in life, although we live in a pecuniary world, can be resolved over price. And a simple example is, if a specific type of contract has features which can no longer be priced because technology changed or requirements changed, you may not be able to find the right price. Think of your service contract of your media provider. You may have liked additional media on your mobile phones, which you don't need anymore because you can all procure it over the World Wide Web. So you don't need it. You're not willing to pay a price but you're still under a contract, so how do you price that? So there may be situations where arbitrators cannot accommodate the changes of economic circumstances or any circumstances with price only. That's when they have to look at other options, in particular force majeure or hardship. And I think the key question is, would a party have entered into this contract under today's conditions where the actual contract with all its bells and whistles is no longer relevant? And if the determination is no, then you cannot change the price, but then it may be actual termination or at least excuse of performance of certain obligations. Now, having said that, we all are very well aware of what the substantive law, be it the contract or statutory law or common law principles, say with regards to changed circumstances. But that's a very different issue, which powers judges and even more so arbitrators have. Regular adjudication in many civil law jurisdictions does not entail tampering with contracts in the sense of amending contract terms. Judges' adjudication powers are limited to grant a claim, sustain a claim, or dismiss a claim, to issue a declaratory judgment, or to order cease and desist orders. But they cannot replace the parties under the applicable law. Now, parties don't think of that often when they combine a price revision clause with an arbitration clause. Now, there are many jurisdictions in which, in particular, arbitrators can have the power to amend the contracts, but they must expressly be given such power, either under the arbitration agreement or in the actual proceedings. Sweden is an example. So you find this in the Swedish Act, in the Swedish Arbitration Act, where it is very generally referred to as gap-filling authority, which is an authority of arbitrators to go beyond the scope of adjudication, in particular to amend contracts instead of the parties. Now that's my closing point. My closing point is to be aware when you're drafting arbitration clauses and when you choose the place of arbitration, and when you have situations such as a long-term agreement where you are aware that changes of circumstances may be very probable over the term of the contract, that you must be sure that you already give the arbitrators the authority you want them to have, either to only adjudicate, to say a specific claim for price revision, the price should be 90 instead of 100, is admissible or is not admissible, or if they should say the price shall be 90 instead of 100, by giving them express authority to amend the contract based on the law of the place of arbitration. And with that, I want to give the word back to Nicole and to Sven for closing remarks, because we only have 6 minutes to go.
All right, then maybe just briefly picking up on something that Johannes just explained very well in price review clauses and the extent of the powers of the tribunal. What happens often in these cases when tribunals have a wide power is that the parties have an incentive not to go to arbitration, or at least not to go all the way. And many of these cases do in fact settle because there is such fear of having a non-sensible, non-commercial solution being imposed, not because the arbitrators are not competent, not because they don't understand the parties' businesses, but because it is very difficult, it is very intricate to get the price in a long-term price agreement right as circumstances change all the time. So arbitration can be a powerful tool to bring parties to the negotiating table. It is also a powerful tool to get out of a stuck negotiation. So there is something to be said for granting broad powers to arbitrators, but of course, as Johannes mentioned, that should be very clear in the agreement so that there's no unnecessary dispute about what the arbitrator can or cannot do, or you have your, even worse, you have your award set aside. Nicole, did you want to contribute any other examples on remedies?
Yeah, maybe I'll go off script a little bit in light of some of the things that Johannes and you've said. It goes back to a point I mentioned earlier, which is sometimes you got to think of a little bit outside of the box to address concerns over changed circumstances. But there is the baseball arbitration that that is used here in the U.S. But I've seen a hybrid just a matter of a few days ago, where the parties have. I've never seen this before, but let me just describe it and try to tie it to our discussion here. But the parties had agreed on the terms of a contract, but they decided to close it, knowing that some of the terms could not yet be agreed in light of certain conditions that had to be satisfied, but they had, for other commercial reasons, to close the agreement. And they initially thought to give it, to impose a 30-day negotiation period on themselves to complete, all the other terms, and give it. And if they were unable to give it to arbitrators to draft the remaining agreement to complete the transaction, which in 2 decades I've never seen this before. So, but that was a very, very broad mandate for arbitrators with certain, obviously, qualifications and the like. But again, and as I mentioned, there are other mechanisms, right? And instead, obviously, they settled on having this 30-day negotiation period. And instead of just giving arbitrators the very, very broad powers to draft missing terms, they decided to try to agree, which is obviously an obligation. But if they couldn't, then each party would draft the agreement that they thought was adequate to complete this overall transaction and send it to an expert panel who would look at the two proposals and just choose one. No? Now, this is obviously a different scenario from that of changed circumstances. It's more like incomplete commercial issues, but it goes to the point that if there is obviously a contractual framework within that gives the tools to the arbitration panel to adapt the contract, that's one thing. But if a contract is lacking those tools, like Johannes said, sometimes you just can't foresee the changes. If it's a 30-year contract, the things that are rendered moot just by the technology, by the passing of time or the current circumstances, then maybe you think of, particularly as Sven mentioned, you sometimes need to come negotiate. Then you think of a mechanism that would allow you to take into account those changes and have those determined without the uncertainty of giving very, very broad powers, like the case that Sven mentioned that was upheld in the US. There are ways in which you can control that uncertainty. And with that, I think, Sven, I'll give it back to you.
All right. Sven, can I jump in quickly here? Because I think that was so important what Nicole just said. And I think one of the important principles we have not yet covered is the dilemma arbitrators and the parties face in situations where the circumstances change so much that the available remedies, even if the parties in the price revision clause, may not be possible to accommodate the actual change of circumstances. And this dilemma is that there is a reason why parties enter into long-term contracts. It's either the necessity of security of supply with something, let's say energy, but reversely, it is also the importance of being able to finance projects. And Sven, you mentioned a couple times LNG projects, and they will be of enormous importance, in particular in Europe, to accommodate the paradigm shift of EU energy regulation. And it would be unfortunate if another change of circumstances, which we all cannot foresee today, comes during the terms of these projects, where the parties or the arbitrators are left with just terminating the agreement and then facing the problem of not being able to finance. Now, the easiest tool, and that's just to sort of distill the thought in a very primitive, workable concept, but which of course is more complicated, is parties can not only agree to a price revision clause, but parties can agree on a general option to be entitled that the contract be adjusted. So a contract revision clause where they can also define what the main principles that have to be preserved will be safeguarded, such as there must be sufficient revenue to pay repayments on the financing agreements. I know this would be opening an entire new panel. I just wanted to bring it in, that it is so important that agreements also be upheld to the extent possible.
All right, thank you, Johannes. So we already have the title for next year's panel. I'll be back here. For today, that's all the time that we have. Thank you again to Nicole and Johannes for a really engaging discussion. Thank you to Hayalsa for having us, and we hope that you and the audience found this as interesting as we did.
Thank you. Thank you so much, Sven. Thank you so much, Nicole and Johannes, for this very thought-provoking and interesting talk. And on behalf of the entire executive board, we'd like to extend we're very grateful for your presence, and we hope to be having you in future YALSA events. We do have a 1 hour and 30-minute lunch break now, and we will gather back again at 2 p.m. EDT for panel 3 on the taking of evidence in international arbitration. See you all at 3. Thank you.
Thank you.
2 p.m. EDT. Thank you.
Bye-bye.